Deputy Cairns, if you want to forsake the 30, there's a minute each for yourself and the Minister.
Yeah, okay.
Yeah. So if you want to take a minute, there's no 30 seconds, we'll just do a minute each.
Just do a minute each. So this issue has arisen due to a recent High Court ruling overturning a 2019 fishing directive which excluded trawling by vessels over 18 metres from waters inside the 6 nautical mile zone. So I wanted to ask the Minister the status of actions you're taking as a result of the High Court ruling that overturned that policy directive, and if an external review of the consultation process, which was found to be in breach of fair procedures, will be conducted. Because this ruling was only overturned on a technical issue, it's been depicted as a good thing for the whole fishing industry. However, that isn't true. The reality is that the vast majority of people working in the sector regard this ruling being overturned as worse than Brexit. This directive would have helped replenish stocks for small-scale, sustainable fishing families, the kind of fishing that I think we should all be supporting. And one of the reasons their voice isn't being heard is because they don't have the same amount of representation. This is desperately needed. So the NIFA and the NIFO have applied for PO status. So I'm wondering if you can give us an update on their status of becoming a producer organisation, and if it's possible to speed that up.
I'll let you over the
minute.
Yeah,
sorry.
We're just finishing up. Minister, one reply, I'm afraid.
Yeah, thank you very much, Deputy Cairns. As you know, in December 2018, following a public consultation process, the then Minister announced that vessels over 18 metres would be excluded from trawling in inshore waters inside the 6 nautical mile zone. And the baselines from the 1st of January 2020. And a transition period of 3 years for vessels over 18 metres targeting sprat was allowed to enable adjustment for these vessels as the sprat fishery is concentrated inside the 6 nautical mile zone. As you pointed out, Deputy, that was subject to an appeal by 2 sprat fishermen on the 6th of October. The judge in the Supreme Court held that the court's final decision it held that the court's final decision final order should be, among other matters, a declaration that Policy Directive 1 of 2019 was made in breach of fair procedures and is void and of no legal effect. The breach of fair procedures I've just referenced related to a failure with obligations to consult with the applicants in accordance with and to the extent required by the consultation process, in particular by failing to consult with them once the preferred option had been identified. I do wish to inform you, Deputy Cairns, that I'm currently considering on an urgent basis the implications of the judgment in consultation with our legal advisers, and I want to also advise you, Deputy, that I'm very committed to the sustainability of fishing in Irish waters and the commitment made in our programme for government that inshore waters continue to be protected for smaller fishing vessels and pair trawling be prohibited within the 6 mile limit.
Thank you, Thank you very much. Thank you for your cooperation. We haven't time for any more. I'll let you over the time. So that concludes this late session, and it's 10 a.m. tomorrow in the Convention Centre. Thank you.